I'm Rob Hassett. I'm a lawyer in Atlanta in technology and entertainment. I did a video a few years ago about what I consider to be the five biggest mistakes relating to limited liability company operating agreements, and it received over 2,000 views. And I needed some of it's out of date, and I thought I'd replace it with this one. This is what I call the six biggest blunders relating to setting up limited liability companies. And I'm going to give you my disclaimer first. This is for educational purposes and it's not legal advice, and I'm sure you've heard that before and you understand why. Um, so back to the six blunders. These are in no particular order. They're all important. The first is that in every agreement, every limited liability company operating agreement, there should be a provision that allows the people to break up in a clean way if they need to, because you shouldn't go into any business without being very certain in your mind that you're going to work out, things are going to work out with your co-shareholders and co-owners, but they don't always, even then, it doesn't always work out. And you need some way to break up, at least for the first 4 years. And one way to do this, if the parties are fairly equal, is to say that I can offer to buy or sell your shares for a particular price. I can offer you to buy your shares or sell mine to you for a particular price, and you have the option to do whichever one you want at that price. That wouldn't work if one of the parties is a visionary behind the company and the other would just be would not want to have the company by themselves. Then you need some other plan, probably based on buyout, based on income or achievements or accomplishments, etc. The second is that commissions are sometimes made payable to people who aren't broker dealers who raise money for the investment for the company. That's illegal in every state, and it can jeopardize your securities exemption, and so it's not something you should allow. Third, fully vest multiple founders on the first day. You want everybody's units to vest over time, except maybe the real um, initiator of the whole thing, because you don't want to be having to buy somebody out who's only been there a year for a third of their stock when they haven't earned it. You have to also ask your tax attorney or your accountant about a Section 83 election if you do that. Delay the vesting. Fourth is ignoring or being unaware of particular law relating to limited liability companies in the state you're in. Those laws vary from state to state. For example, Georgia has a provision that if you don't provide otherwise an operating agreement, you don't provide otherwise, each party has an equal right to vote. Even if I own 90% and you own 10%, we still have equal vote because voting is per capita under the default rules in Georgia. The fifth point is big blunder is failure to consider filing an S election or becoming a C corporation. Limited liability companies are generally taxed as partnerships if there's multiple partners, more than one owner. And that's usually the way to go, but there are situations in which that isn't a good idea. For example, in Georgia, we have tax credits that are up to 30% of the cost of expenditures in Georgia of making a movie, which can make a deal break it or make it. And to qualify for video games, you need $250,000 in payroll. For films, you need $500,000 in expenditures. And those expenditures don't include what are called guaranteed payments for limited liability companies. That's the sort of salary for owners of limited liability companies, but it does apply to income payments, compensation to the owners in an S corporation or a C corporation. So you may need that to count that money in order to qualify for the $500,000 for film or for $250,000 for video games to qualify for the credits. And the credits are huge. They're, like I said, 30%, and they can be sold to the extent not used. There's a big market for them. So you want to be able to You want to have a lawyer that thinks creatively and an accountant that looks for issues to resolve like that. Because you don't want to be at 450,000. You could have made it if you just counted the payroll to the um, owners of the company as part of the expenditures. A sixth is a failure to provide that the company owns all the intellectual property rights of the founders. Not having that can be a big problem because um, then you can have all kinds of lawsuits and security fraud suits, et cetera, later on, because that should be clear that those assets, those rights are owned by the company, and that the founders aren't holding something back in conflict with the investors. I appreciate you watching this video. If you have questions, you can call me at 678-506-8828 or email me at rob@businesslawpartners.com. Thanks.